All right. As you have already seen in the previous chapter, we have talked about the establishment of our government and what the government was established on as far as the Constitution. And we are going to continue through that discussion in this module. We're going to go over how the Constitution serves as a framework for federalism and why debates about the proper role of the federal and state governments are still a question today. We will also, the question of federal versus state government is always in flux. State governments have developed in strength thanks to state constitutions and local government charters, which mirror the Constitution in scope. Citizens are designated as both citizens of the state and the nation, making them dual citizens and subject to both sets of laws. But the system has evolved from dual to cooperative federalism, and we will see how cooperative doesn't always mean harmonious. Federalism has changed over the years, with authority shifting and gaining ground at different times, raising questions about federal and state authority going forward. The initial government of the United States was a confederation or a union of independent entities that were joined for a common purpose. But the joint government had limited authority and its powers were granted by the members. This was the government preferred by the Anti-Federalists, who saw it as the best means of preserving individual liberty. However, it was difficult to govern. We can see how it worked or didn't by studying the United Nations. UN decisions are hard to enforce because nations aren't compelled to comply, and members can withhold contributions, affecting resources. Members compete rather than work together, and this was very much like what it was when America was under the Confederation. The framers preferred a unitary system in which the lower levels of government, that is the states, are subordinate to the national government and are limited in activities such as raising funds and self-governing. This is the model seen in the District of Columbia. State governments can self-govern, but their local municipalities are unitary and completely subordinate to them. So I want to challenge you to think, what if the United States had adopted a unitary system of government instead of federalism at the Constitutional Convention? How would politics and policies in the United States be different today? Also, think about how the U.S. system would be different if we had retained the Confederation system that existed under the Articles of Confederation. It would be very different than it is today. When the United States was first formed, people felt a stronger allegiance to their individual states rather than the single new nation state. Exactly how much power the national government would have was a matter of debate from the beginning. Thomas Jefferson advocated for a compact theory of federalism, making the states the sovereign entities that were joined together. In this case, sovereignty is the ability of a state to have the ultimate authority to make decisions about what happens within its borders. This was particularly important to the South, which wanted to be free to carry on their slave-based economy. Their determination to be sovereign led to the doctrine of nullification, which claimed that states could nullify federal laws they disagreed with or felt violated the letter or spirit of the Constitution. In the North, the nationalist theory was more popular, indicating that the Constitution represented the people as a union rather than as a group of states. The debate over the balance of power between the national and state governments was an issue from the outset and continues to be hotly argued at times, with various laws at the center of the question. The ways by which power is distributed in a confederation, federal, and unitary system are illustrated here. We see that the federal system is a blend of the other two forms, though the national government still has primacy over the states. The confederal, federal, and unitary systems of government provide alternative distributions of political power. The confederal system places sovereignty in the subnational governments, while the unitary system places it in the national government. The federal system, like ours, is a blend with sovereignty at both the national and subnational levels. The ways by which power is distributed in a confederal, federal, and unitary system are illustrated here. This image is showing you how federalism actually works. There are specific national powers, specific state powers, and then there are powers that come together that the two states actually share, forming a federal system. The system that prevailed is one that works as a middle ground between confederal and unitary systems. Federalism distributes power throughout the national and subnational governments. In our case, that's the states. It allows a certain amount of self-government. The Supremacy Clause in the Constitution states that when national and state laws are in conflict, the national laws have primacy. At the same time, the 10th Amendment specifies that state governments are guaranteed powers other than the ones granted by the national government, or not specifically prohibited. These powers are called reserved powers. The Constitution also insists upon fair play between the states, so no one has primacy over the other. Three important clauses, the Full Faith and Credit Clause, the Equal Privileges Clause, and the Immunities Clause, and the Commerce Clause are critical for keeping states from discriminating against one another and working on their own to form their own foreign entity. The American system of dual federalism and cooperative federalism creates separate and independent governing entities at the federal and state levels. Dual federalism in practice has been reinforced by the Commerce Clause in the Constitution, and more specifically, the Supreme Court's interpretation of the scope of Congress's power to regulate interstate commerce. The model of dual federalism that characterized the 19th century has shifted somewhat since the 1930s, but we still see the division of authority and responsibility between the national and state governments. Now let's look and talk more about dual federalism and how it has evolved. Again, this is an image that you can study to see the balance of power between the national and the state governments. In moving the political system from dual to cooperative federalism with McCulloch versus Maryland in 1819, this case actually helped to establish some boundaries. The case concerned the Second Bank of the United States, which was chartered by Congress and had a branch in Baltimore. Since banks had traditionally fallen under the purview of the states, Maryland taxed the bank, and the tax was challenged by the federal government. The Supreme Court determined that Congress could charter a national bank because it had the power to pay debts, to borrow money, and to regulate commerce. These powers are called enumerated powers because they are specifically listed in the Constitution. The Constitution does not state that Congress can charter a bank. However, under the Necessary and Proper Clause, sometimes called the Elastic Clause, for reasons that should be clear, in the Constitution, Congress has the powers to do what is necessary to carry out its enumerated powers, or those powers that are specifically listed. So the Necessary and Proper Clause gave Congress implied powers. Since Congress had the power to regulate currency, it had the power to create a bank. Moreover, the state could not tax this bank. The court announced the power to tax involves the power to destroy, and the state could not destroy a national entity. From the outset of the nation's foundation, the issue of interstate commerce has been at the forefront of debate. The Commerce Clause of the Constitution announces that Congress has the power to regulate with foreign nations and among the several states and with the Indian tribes. So while a state could trade as it liked within its borders, once it wanted to do business with another state, it was then subject to federal law. In an 1824 case, Gibbons versus Ogden established federal dominance over interstate commerce. 2 New Yorkers were granted the right to operate steamboats on state waters. But of course, the water flowed into and out of other states. So New York required a state permit to travel on New York waters. One of the owner's businesses required travel between New Jersey and New York, and so challenged the permit law. The court decided that the federal law over trade overrode the permit law in New York. They were navigating interstate waters and therefore were subject to state law. The laws continued to evolve, with various later decisions limiting the scope of the federal government. In the early 20th century, federal regulations expanded to create what became the Food and Drug Administration, so that the federal government monitored food and drug safety and assured accurate labeling. This was allowed because of the effect labeling has on trade. Later, the Federal Trade Commission was formed to monitor false advertising and incorporate mergers, which could also affect commerce. The need for cooperative federalism became very serious in the 1930s during the Great Depression. State officials needed the assistance of the federal government to help citizens, and the federal government recognized that it needed to assist all citizens equally. The case of National Labor Relations Board versus Jones and Laughlin Steel Corporation in 1937 allowed for an expansion in the definition of interstate commerce. Jones and Laughlin had fired workers for unionizing. This was in violation of the National Labor Relations Act of 1935, which said companies involved in interstate commerce could not disallow unions. That means that they had to allow their workers to participate in unions. The company argued that labor management relations were not part of commerce and so were free from federal regulation. It said what happened inside a factory was manufacturing and nothing to do with interstate commerce. So the act was an intrusion on business practices. The Supreme Court said this was too narrow and that a company that uses interstate products or sells interstate is thus part of interstate commerce, and so its business practices are subject to Congress's laws. Specifically, troubled relations between labor and management could lead to a strike, which could also affect commerce. This decision gave the federal government power over issues like workplace safety, hours, conditions, and overtime pay. In Wickard versus Filborn in 1942 took it further, ruling that an activity that has a substantial economic effect on interstate commerce can be regulated by the federal government. The recent healthcare reform legislation has been debated on grounds of interstate commerce. The law required that individuals buy insurance and that insurers are also required to insure anyone regardless of condition. Opponents said this was forcing an individual to enter interstate commerce against their will. Supporters said it was necessary and proper because to be uninsured negatively affects the market and so is an economic activity subject to commerce laws. Next, we're going to look at the relationship between state and local governments and consider the special case of Native American tribes. States and cities have their own framework for government organization, and they are structured in a manner similar to the Constitution. States have their own constitutions and local government charters. But first, I want to show you this example of marble cake federalism versus layer cake federalism. And so dual federalism, which actually came first, is a very good, the layer cake is a good example of dual federalism. There was a clear demarcation of authority and between programs and government and state, federal and state governments. The marble cake federalism is much more the cooperative federalism, where national, state, and local government authority overlaps. So, like I said, we are going to now look at cooperative federalism and the relationship between the state and the federal governments. The federal governments are definitely traditionally more powerful within this arrangement, so that cooperative does not always mean that they get along. There's an extent to which mandates are seen as coercive, and fiscal federalism puts pressure on state officials to adhere to federal policy. The reforms that first came in the 1910s and then the 1930s required cooperative federalism. During the Great Depression, government action was needed to help an economy that was really struggling and high unemployment. States were unable to cope and so were much more open to working with the federal government than they ever had been before on matters that previously had always been their sole jurisdiction. Welfare, unemployment insurance, and jobs programs were now jointly funded and run by the national and state governments. Although the states were receptive to these new federal programs, The legislation might not have been supported if states had not been given some say in it. Some politicians, excuse me, state politicians wanted to hold on to power, and Southern states in particular did not want interference in their social structure where blacks did not have the same rights as whites. For example, to pass the minimum wage law, Congress allowed agricultural workers to be omitted. Black workers in the South were not able to command more reasonable wages, and welfare was another contentious benefit, where the states had leeway in how they wanted to administer the programs. New legislation in 1996 changed the system so that each state's program is different but operates within national guidelines. States are allowed to pay minimum wages that are higher than the federal standard. In some cases, they can also offer a minimum that is lower than the standard or no minimum at all. Look at this map and I want you to think about which states offer higher or lower minimum wages. How national and state governments collaborate varies by issue. The federal government will establish standards which the states must comply with, but are allowed to exceed. Basically, states are free to mold the policies to suit their needs so long as they fall within the stated guidelines. Environmental laws are a great example of how this works. After the passage of the Clean Air Act in 1967, states were required to bring down emissions to control pollution. California imposed higher restrictions on emissions than were demanded, in part because they had suffered a great deal from pollution. This allowed other states to choose the California model if they wanted to, and 13 other states actually did. A more controversial issue is immigration. States must adhere to federal law, but they can choose what benefits and services immigrants receive. This applies to legal as well as illegal immigrants. Despite what the media would have you believe, collaboration has been much more of the norm in most instances. Many states find it a burden to enforce federal immigration laws. On the other hand, some states have been said to exceed what is appropriate in their handling of immigration issues. When Arizona passed a law that said that they enhanced the enforcement of standard procedure, opponents said it was only served to harass Latinos, the bulk of whom were in the country legally. I want you to think about on your own, what do you think is a fair policy regarding immigration law enforcement? Because it is very much a contentious issue, especially with the latest election of our president and the contention over the issue between the left and the right is constantly in the news, and it is an area that our national and state governments have not come to a place of agreement on. The federal government has the power to issue a mandate, forcing states to take certain actions in issues. This increased dramatically in the 1960s as the overall push for greater civil rights was growing. States were compelled to abide by laws such as the Individuals with Disabilities Education Act, which requires that students with learning or physical disabilities must have equal education opportunities. States are given some federal assistance, but states often find the burden to be too much. State officials resent mandates because they force actions the states would rather not take. Unfunded mandates require states to fund actions themselves. The Republicans have fought to have them overturned, but this is definitely an ongoing issue. The federal government can compel states to take action through persuasion. One popular method of persuasion is fiscal federalism. This is very simply using federal funds as an incentive to get states to act. A categorical grant gives money that can only be used for a very specific purpose. The state or locality must agree to this purpose and abide by the restrictions. A number of rules are in place to make it difficult for a state government to change course on a categorical grant. They can come in the form of a formula or a competitive grant. Block grants allow the states more flexibility and are usually geared toward programs like transportation, welfare, child care, and homeland security. They do come with conditions, and funding can be lost if standards are not met. This table demonstrates the ways in which the federal government compels states to take certain actions. They can use mandates, which states must follow, even if the states do not receive funding. The federal government can also use persuasion, with financial incentives to encourage states to take action. The funds come with conditions, and if states do not comply in full, they will lose funding. How we see the percentages of federal aid to the states receive, here we see the percentages of federal aid the states receive for complying with federal laws on education, health and community, and regional development. As you can see, the money provided for health care has risen considerably. Certain regions are now receiving more in federal spending than they actually pay in taxes. The South and the West are the largest recipients of federal aid. Why do you think that these regions need the most aid and pay the fewest taxes? And do you think that that is fair? As we will talk about in this next section, the last 2 decades have seen changes in the relationship between the federal and state governments. In many ways, the shift has been toward greater state autonomy and self-authority, with state officials making more policy decisions and national leaders allowing states more overall flexibility and responsibility. The Supreme Court has sided with states' rights and against federal responsibility in a lot of cases, arguing that Congress has overreached in its use of the Commerce Clause and that state sovereignty grants more autonomy from federal regulation. There are a few policy areas, however, where the federal government is becoming more involved. As we will look at, the role of federalism in the United States is constantly changing. The shift of authority and responsibility to the states began in 1994, after the Republicans won control of the House and Senate. They pushed for devolution, which means a transferring of authority downward, and made the federal government cede power to the states. One of the biggest examples of how devolution works and affects citizens is with the reform of the national welfare system in 1996. The use of block grants led to each state creating its own system for distributing and monitoring welfare benefits. The number of people receiving benefits and the level of those benefits dropped, although the number of people living in poverty did not decline by a great deal. But overall, welfare reform has been successful. States have also gained more power through negotiated rulemaking. Congress requires that federal agencies negotiate with both states and other interest groups to determine the law's content and implementation. States cannot veto a law, but they have a formal and ongoing, but they have a formal, pushing through the slides here, and I shouldn't. They have a formal and ongoing role in developing the regulations. The Supreme Court has also issued rulings that contribute to the shift in power from the federal to the state governments. This also began in the mid-1990s when the court scaled back Congress's use with the Interstate Commerce Clause as justification for legislation that states considered intrusive. The courts considered that it was upholding the 10th Amendment, which states that powers not delegated to the federal government are for states or people, and the 11th Amendment, stating that the federal judicial power does not extend to cases of private individuals against the states. In this way, the court also upheld the ideals of dual sovereignty, originally championed by anti-federalists during the ratification debate over the Constitution. The court's decisions were mostly a 5-4 narrow majority and welcomed by conservatives while denounced by liberals. The distribution of authority from the federal to the state level has given states more power. Conservatives and liberals have both used state authority when they feel it necessary to achieve a policy that they don't think will prevail at the national level. The pull and tug has led to unexpected consequences. In the case of the Real ID Act of 2005, you have concerns over terrorism, which is clearly under the federal government's jurisdiction. clashing with driver's license, which are very much a state concern. The act demanded that all states see proof of citizenship or permanent residency prior to issuing a driver's license. Further, state licenses were to be standardized throughout the country, and it was argued that this would help fight terrorism. Opponents saw it as an unnecessary expense and threat to privacy rights. Most states pushed back, and the federal government has had to pull away from this legislation as well. The strong shift away from federalism as it has characterized American politics for so long are sometimes described as a revolution. A deeper look, however, suggests that this question of a state versus federal government is far more complex. For one thing, even where devolution has occurred, the federal government still sets certain standards. States can tailor their welfare programs as suits them, but they cannot abandon the programs. Acts such as the National Voter Registration Act and Help America Vote Act are designed to simplify registration and voting procedures so that everyone might exercise their civil right to vote. States have bristled at some of the legislation, but they must comply. The national government has also set standards for education, with George W. Bush and the No Child Left Behind Act and Barack Obama's Race to the Top program. These reinsert a federal role in the state education programs. Furthermore, there have been instances of the Supreme Court curbing state powers, specifically when the question of equal protection outlined in the 14th Amendment has been in play. Federalism continues to evolve through different needs and interpretations of laws. The balance remains tricky, and the pull and tug continues. And this will be an issue, a topic that you will continue to see evolve throughout your lifetime as well. So I challenge you to pay attention as you read the news, as you watch the news, watch for the pull and tug between the national government and the state governments as they sometimes fight for who has authority and jurisdiction to make decisions.